If you became a US citizen through naturalization, you were probably told explicitly or implicitly that this was the final permanent step. For most of modern history, that belief has been well founded. Citizenship has been understood as a stable legal status that does not get revisited once it is lawfully granted. As we move toward 2026, however, many naturalized Americans are starting to hear unsettling headlines and online claims suggesting that past citizenship cases are being reviewed more closely than before. This has led to a lot of understandable anxiety and one central question: can U.S. citizenship ever be taken away, and who is actually at risk? This video is about answering that question calmly and factually, separating what is legally possible from what is being exaggerated, and explaining what current enforcement trends really mean for naturalized citizens. I'm Sophia, and my goal is to explain immigration and policy developments in clear, practical language without panic or political hype. Immigration systems are complex, and when people don't get clear explanations, fear fills the gap. So let's slow this down and walk through what is actually happening. For decades, U.S. citizenship has been considered one of the strongest legal protections in the world. Once someone completed the immigration process, passed background checks, lived as a lawful permanent resident, and took the oath of allegiance, that step was widely viewed as final. People built their lives around that certainty. They bought homes, raised families, started businesses, and planned for the future with confidence that their legal status was settled. That core understanding has not disappeared. Citizenship is still protected by strong federal law. The government cannot revoke citizenship simply because policies change or priorities shift. There is no general process for reviewing citizens just to see if something turns up. What has changed and what is driving concern is how the government is approaching a very specific and historically rare legal process known as denaturalization. Denaturalization is not new. It has existed for more than a century, but it has traditionally been used only in exceptional cases where the government could prove that citizenship was obtained through intentional fraud or deliberate concealment of material facts. That legal standard is high, and it still applies today. In recent years, immigration agencies and the Department of Justice have shown greater interest in identifying old cases that might meet that strict standard. That includes reviewing records where there are allegations of serious misrepresentation, use of false identities, or concealment of major criminal history during the naturalization process. This shift in attention has led to reports that older files are being examined more systematically than in the past. That change in emphasis, not a change in the law itself, is what has raised alarm among some naturalized citizens. To put this in context, it helps to look at history. For many years, denaturalization cases were extremely rare. Across the entire country, only a small number were filed annually, usually involving clear evidence of intentional deception. Compared to the tens of millions of naturalized citizens living in the US, the numbers were tiny. Even today, denaturalization remains a civil court process, not an administrative action. The government must bring a formal case before a federal judge and meet a demanding burden of proof. Honest mistakes, memory gaps, translation issues, or minor inconsistencies are not supposed to qualify. The law draws a clear distinction between deliberate fraud and ordinary human error. That said, legal experts have noted an important practical concern. When enforcement efforts place more emphasis on identifying potential cases, there is a risk that scrutiny increases overall. In any system, greater review can bring more questions, more requests for explanation, and more stress for the people involved, even when no wrongdoing ultimately exists. This is why some naturalized citizens feel unsettled. Many applications were completed years or decades ago, often on paper, sometimes without legal help, and sometimes in a second language. Records may not align perfectly with modern databases. Dates, addresses, or job histories may not match exactly across different filings. None of that automatically means fraud, but it can still feel frightening to imagine old paperwork being re-examined. It's important to be very clear here. The vast majority of naturalized Americans are not at risk of losing their citizenship. People who obtained citizenship lawfully answered questions honestly and did not deliberately hide disqualifying information remain strongly protected under the law. Government officials who support increased denaturalization enforcement emphasize that their focus is on serious cases, situations involving intentional deception, false identities, or hidden criminal conduct that would have disqualified someone from citizenship if known at the time. From that perspective, enforcement is framed as protecting the integrity of the system, not targeting ordinary citizens. Critics, however, argue that broader enforcement efforts can create fear well beyond the small number of actual cases. Even the possibility of review can cause anxiety, especially in immigrant communities that value stability and certainty. That emotional impact is real, even when legal risk is low. This debate is part of a larger shift in immigration enforcement more generally. Over the past several years, policies have increasingly emphasized verification, documentation, and compliance. What makes denaturalization discussions feel different is that they involve people who already completed the process and believed their status was fully settled. For naturalized citizens, this raises deeper questions about belonging and permanence. Citizenship has always been understood as placing naturalized and natural-born Americans on equal legal footing. Any suggestion, real or perceived, that citizenship could feel conditional understandably challenges that sense of security. So, what should naturalized citizens actually do in response? The most constructive approach is preparation, not fear. Immigration attorneys consistently recommend a few practical steps that reduce uncertainty. First, keep copies of your immigration records if you have them. That includes green card applications, naturalization forms, and supporting documents. Many people already have these, but they're often scattered or incomplete. Organizing them can provide peace of mind. Second, understand your own history clearly. If you know there were complex issues in your past, such as prior immigration filings, name changes, or legal matters, it may be worth discussing them with a qualified immigration attorney, especially before making major applications or international travel plans. Third, stay informed through reliable sources. Immigration law evolves through policy guidance, court decisions, and agency practice, not just headlines. Avoid reacting to rumors or social media claims without verification. Most importantly, remember this: citizenship still carries strong legal protections. Denaturalization remains difficult for the government to prove and is not a routine process for ordinary people who followed the rules in good faith. As 2026 approaches, conversations around immigration enforcement are likely to continue, and new details will emerge through official guidance and court cases. The best response is staying informed, organized, and grounded in facts rather than fear. If you value clear, balanced explanations like this and want to stay updated as policies evolve, consider subscribing so you don't miss future breakdowns. Understanding the system is one of the most effective ways to protect yourself and your family. Thank you for watching, and I'll see you in the next update.